We are back on Morning Line. It's our final segment with malpractice attorney Clint Kelly joining us via Zoom and taking your phone call, 737-7587. And Clint, remind folks again, if someone wants to get in touch with you and your office during this pandemic, are you still at the office? I know you take phone calls. How does that work out now if someone has a case they want to ask you about?
Sure. You call the same number at 615-8000000. It's 800-0000, and call and ask to speak to me or Michelle, or just call in and say, look, I've got a case of medical malpractice I want to talk about. The call is free. It's confidential. What happens is you give some information to my legal assistant, who is also has nursing experience. She will then get that information to me. I'll review it. If I think the case has merit, I'll contact you directly, and we can either meet at the office. I got lots of room there, or we can do it by telephone, or we can do it by Zoom. There's all kinds of ways to do it. But the key thing to remember is you don't pay anything unless we recover money for you.
That's right. And as far as, the cases you handle, you settle many cases, but you also are more than willing to litigate if it comes to that. And I'm just curious, what are you seeing right now? I heard some rumors that at some point they're beginning to lean maybe later this summer into opening up with some jury trials. There are none happening right now. What are you hearing about how you have to do your business when you're dealing with the courts?
Well, you are correct. I'm hearing that we may start having jury trials in August. Knock on wood, we hope so, certainly by the fall. But there is a huge backlog of cases right now, and I don't know if they're settling or whether they're just going to get reset into the next year. But the courts are going to have some time breaking through the logjam. The good news, like you said, is most of my cases settle. It takes a while. You work them up. But in most instances, the hospital, the doctor's willing to write a check to my clients to bring the case to a close. But there are some instances where we can't agree. I got one right now where we just cannot agree, particularly on the value. Sometimes they're just too cheap. They don't want to pay what they should pay. And that's where juries come in. So that case was originally set to go in March. It got moved because of COVID, and now because of scheduling issues, we're not going to be able to reset that case for trial until January.
That's crazy. I almost wonder if in some twisted way, pandemic and the delays have come out in the favor perhaps of the defendants in these cases, simply because, all right, you've got a plaintiff that maybe wants to settle and try to get some damages for whatever happened to them, but you can't reach that settlement, and meanwhile the defendant can say, well, we're not going to settle, and hey, meanwhile, this ain't going to trial for a long time. Maybe you should redo. You know what I'm saying there? Could that in some way have an impact on it?
You're absolutely right, because remember, all doctors and hospitals have insurance. Let me say that again. All doctors, all hospitals, all nurses have insurance. So when you bring a claim against them, they're not paying out of their pocket, their insurance company is. Well, when you sue, the insurance company puts enough money in reserve to cover the claim. That reserve sits in a fund. It can be in a stock market mutual, it can be an annuity, it can be in other types of investments that draws interest over time. So the longer the case gets put off before the insurance company has to pay, the more money they're making on top of money. And usually they're in the type of accounts, they're not like equities where tomorrow the stock market goes down 700 points, their reserve loses money. They usually purchase an annuity that's a guaranteed rate of return. It might be 1%, 2%, 2.5%, but it is money that's being made every day while it sits before it's turned into a check paid to the injured party.
I did not know that. I didn't know that. I just thought that they have a huge reserve fund to put aside, but when they have a case, they actually look at what someone's asking for in a lawsuit, not that they're going to pay it, and they say, well, let's just set aside this $100,000 over here. That's there if we lose. And it can gain interest, and if it doesn't, then we obviously put it back where it was before. I didn't know that's how that. I guess that's wise if you have the means to do that, right?
Well, it is. It's their worst case scenario money. Their job is to make sure they've got enough money to pay the claim. So they'll look at the claim, they'll say, here's the worst case scenario. We'll set that money aside, knowing that it's highly likely they won't have to spend all that money to settle the case. But they're earning money on top of the money because that money draws interest. So getting back to your original question, it is to their advantage to have cases continued.
Yeah, most defendants, whatever the case, criminal or civil, do not mind delays. Let's put it to you that way. They never met a delay they didn't like. Let's just get back in our remaining moments then, Clint. Can you share with us how many clients you do have out of Gallatin and maybe just what the status of that is, separate, of course, as you said, from what's happening in the legislature?
Sure. We have 22 total clients. 17 of those folks are residents and their families. 5 of them are former employees who got sick at the facility. We are still in the midst of performing an investigation. The reason why we haven't been able to do it any faster is the hospital, Sumner Regional Medical Center, has been slow to get the medical records out because of their coronavirus protection. So it's been, we've been kind of a creeping disclosure trying to look at those records. So unfortunately, we've not been able to file suit as quickly as we want, but we're in a position now where we believe we'll be able to file lawsuits as a group sometime within the next 30 to 60 days. And when we do, I'll let you know.
So at the stage then that you've submitted the letter of intent to sue, have you heard back from them yet? How does that work?
Yeah, haven't heard anything, but that's not unusual. Typically, you don't hear anything from them. They just basically take that letter and throw it in the trash.
Okay.
So, yeah, I haven't heard anything.
Okay, and that copy of the letter, though, sets the date, the clock's running, and then, the courts maybe have that, and when it's 30 days or whatever after you've sent the letter, right?
That's correct. And believe it or not, that letter is a very technical letter. It has to be done properly. You don't want any old lawyer to do it. You need someone who's a medical malpractice specialist to draft that letter and send it.
And again, if you would, just the nuts and bolts of the allegations you'll make in the lawsuit is just pointing toward gross negligence. Is that the argument, that this was not something where COVID just got in through no fault of their own, but that the argument is going to be there were steps that could have been taken to prevent this that weren't up to standard of care? Is that the argument?
Yeah, you just said it all yourself.
Okay.
I mean, if I want to make it really simple, the argument is they let the burglar in the door by leaving the door unlocked, and then they let the burglar completely rob the house.
Okay. And a case like this, I know there have been others around the country and certainly around the state. Is this something that can become a class action? When you say there's several together, or is it just each individual family?
It's each individual family. We'll just group them together and try to hold them together in one lawsuit so that each of the claims can be dealt with without having to have separate lawyers and separate experts for all of those cases. And we hope that will take place. But each claim is individual, will have to be decided individually when the time comes. And my hope is that these cases will settle, that the nursing home's insurance company will get together with us and come up with a reasonable figure to compensate these poor families for what they've had to go through, because they've gone through a lot.
Yeah, they sure have. Boy, I'll tell you, and we'll see as more perhaps comes along. I just don't know. Clint, beyond that, are you ready to get back up and running? I know society is slowly but surely opening up. Will you be back at your office? I know you, and knowing you, you're exercising caution and social separation, and you continue. But I'm optimistic, hopefully, that things get better, though we may see some spikes initially here as things reopen.
Nick, do you know what I'm really anxious to do and what I'm looking forward to doing?
What's that?
I'm looking forward to a handshake.
Yeah. How about that, instead of an elbow bump or waving from a distance, right?
Yeah, I'm looking forward to meeting clients, witnesses, other lawyers, and being able to walk up and shake their hand. I hope Fauci's not right. I hope that we're able to do that in the future. But I'm ready to be around people again. I'm ready to interact. That's what, as a lawyer, you do. And I'm ready to sit down and speak to people about their rights in medical malpractice cases and be able to look them in the eye or sit across from them at the table and feel what they go through, because that's part of the joy of this work, is being able to help these people, understanding what their problems are and absorbing the emotional pain, that you use that as your energy to try to get them compensation and get some justice.
Yeah, I couldn't agree with you more. And I know you're a social person, but it's the same way even in the news business. I know exactly what you're talking about, picking up the emotion. There's a certain degree lost in the translation electronically or talking when you can sit face to face. Or Clint, you know as well as I do, when you're sitting here next to me, and you and I are friends and there's a camaraderie there and it just goes, there's just something more comfortable about that. Not that this isn't working just fine, but it is different,
Yeah, there's nonverbal communication. There are things that you and I can do just when we're sitting together with each other where we can communicate with each other nonverbally, and it flows better as opposed to what we're doing here, which is fine. It's a good temporary measure, but I far prefer being around people because I think the experience and what you're doing is superior than simply doing it by Zoom.
Yeah, well, and it will be interesting to see that the big stumbling block, and as you always say, you'll litigate if you have to. I'm still wondering how they're going to go about doing juries, all right? The jury selection and all that. I mean, how are they going to get past that until we know maybe that, COVID is kind of wiped out or there's a great vaccine or a great treatment? I just don't see how you do that and get a jury.
Let me suggest something. I hope the Supreme Court will do this. They need to cut the number of juries from 12 to 6. That would make a huge difference.
The number of jurors?
Yes, they need to cut the number of jurors from 12 to 6, because then in that jury box, they can sit much further away from each other, and they can go into the jury room, and they can still sit further. There's more social distancing. We don't need 12 jurors anymore, Nick.
Okay.
6 are plenty.
Really? For real? I hadn't thought of that. Is there a constitutional requirement there? I don't know where 12 comes from, but that's interesting. That's the first time I've heard that.
Yeah, it's not written in the Constitution, although the courts have viewed that as a constitutional right. But under their emergency powers, the Supreme Court has emergency powers. They could lift that restriction if they wanted to and start having 6-person jury trials. They've already recommended it to the lawyers. My question is, when are they going to start enforcing it and saying this is the rule going forward?
Holy cow. That's great. So the judges, at this point, could a judge individually in the Birch Building just say, okay, we're just going to have 6 jurors instead of 12?
If the Supreme Court lets them do it, yes.
Lets them do it. Fascinating. Clint, just really enjoyed talking to you. Thanks so much for joining us today. We'll see you again in a month. You take care of yourself and keep in touch. And as we leave you, we'll make sure to put up the information on how folks can contact you, all right?
Thank you, Nick.
Take care.
Good talk to you again.
Be well, my friend. All right, we'll take a break. When we come back, programming note. We'll wrap things up for you and take it from there also. We'll have a pen and paper for you, or you get yours ready, and we'll put that phone number up on how you can reach Clint Kelly. We'll be back right after this.